Hello, I am Crystalline Holiday. I'm an attorney in Brookfield, and I wanted to talk with you about the state court system. So, in Wisconsin, like other states, we have a state court system. The state court system is a court system that relies on state statutes and state legal precedent. In Wisconsin, we have a set of county seats, county circuit courts. So, every county has an operating court system in some fashion. In Waukesha County, we have 12 branches, which means that we have 12 judges that operate in the Waukesha County Courthouse. Those judges are elected, not appointed. We are actually in the middle of an election season where some judges are vying for limited benches that are available in Waukesha County. These judges, unlike the federal system, have clerks that are generally not lawyers working beneath them and helping them to process cases through the courts. In Wisconsin, and like in other cases, if you don't agree with a decision rendered by a circuit court in a state, in a county, then you can appeal that decision. You can appeal that decision to the Court of Appeals. There are different divisions of the Court of Appeals in the state of Wisconsin. I believe there are 4 separate divisions for the Court of Appeals. We are, I believe, District 2 in Wisconsin, where you would appeal a decision of a trial court to. The Court of Appeals office is administered through Madison, regardless of the division where you're appealing to, and the clerk is in charge in Madison is in charge of managing all of those appeals. The Court of Appeals for our different districts are multi-judge panels as well as the federal model. So that Court of Appeals appeal that you'd file would include a brief that you would have to write to the court. You'd have to, again, provide the record like you did in a federal case, including a transcript of the hearings, all the pleadings, all the exhibits, so that the Court of Appeals would consider your case. Generally, courts of appeals do not hold oral arguments in Wisconsin. They reserve that for the Supreme Court of Wisconsin. Then your appeal would be considered at the Court of Appeals level. They would evaluate the record, just like they do in the federal level, and make a determination about whether the lower court made the right decision. So generally, all decisions of those lower courts are appealable, meaning you can, if you feel that the decision was wrong on the merits or procedurally there were some issues with it, then you can appeal it to the higher court, which is in Wisconsin, the Court of Appeals. The decisions generally take a long time to get rendered, and the Court of Appeals does not have to accept your case for appeal. Then if they do accept it, they evaluate it and then render a decision. They can do it by a multi-judge panel, or they can do it en banc, which means that it's just sort of an unnamed judge writing the decision and rendering it to the appellant. Then, if you don't like the decision based on what the Court of Appeals has indicated, then you have another level in Wisconsin. That's the Supreme Court of Wisconsin. Supreme Court judges are elected. They are appointed when there's a vacancy in the Supreme Court, but they are generally elected by the state to the bench. The Supreme Court makes a decision about whether or not they're going to hear cases based on what the cases are composed of. Sometimes and often they will determine, no, the lower court did everything that they were supposed to do procedurally, so there's nothing that we need to upset, so we will let the decision stand. Under those circumstances, then they issue a determination that it is affirmed, we're not going to upset it. Decisions can also be reversed entirely, with the Supreme Court saying, this was not appropriate, we're going to do the opposite of what the lower court said, whether it was Court of Appeals or the trial court. Or they can say you got it partially right, and we're going to direct the lower court to make this change. We will remand it to you for a change. Cases at the Supreme Court are also cases that are heard with oral arguments, just like the Supreme Court of the United States. And like the Supreme Court of the United States, they will hear oral arguments from both counsel that are in the case, and they have to go to Madison to make those arguments. There is another aspect to these state cases, which is that when when the court is dealing with a unique issue of law at the Court of Appeals level or the state's Supreme Court level, and by a unique issue of the law, that means an issue that is not well settled in Wisconsin or creates a new law, because laws can be created by court decisions. In those cases, in Wisconsin, those cases will be determined to be published cases. And I put air quotes on that because having a published case means that it is controlling law that attorneys can later cite in legal briefs as authority for their positions. So, for example, I had a case where I represented a baby, actually, in a termination of parental rights case. I was the guardian ad litem for the baby, and the father of that baby was a youth, but also was a sexual predator and had been convicted of crimes against another victim. And so my contention to the court was that the records of the father of the baby that I represented should be opened to the court and considered in determining whether the claim for termination of parental rights should be granted to the mother who did not want the father to have access to this child because of his prior record. The court then decided, yes, it was relevant to the termination of parental rights case, but we didn't have any law on that. So that decision became a published decision, which is now and was at the time controlling law for attorneys who practice in the area of termination of parental rights. So they made new law with that case because of the fact that we didn't have a statute to regulate it. And so the facts of our case presented a unique fact question that had to be considered by the state court. And then we got a Court of Appeals decision on that, which the biological father in that case did not appeal to the Supreme Court. And so the Court of Appeals decision stood and is a published case in Wisconsin. And all attorneys who practice in that area rely on that case where their facts are similar. So that's how, in one way, that new law can be made is by these published court decisions in the state of Wisconsin. And then sometimes other cases come along upending those cases, and they can be overruled. And if those cases are overruled, then that subsequent case creates even new law that other attorneys will rely on for the future. So the court system in Wisconsin and the federal system are, multi-leveled mechanisms where you start at the lowest level, and if you don't get the right decision, what you believe is the right decision, you can appeal it to a higher level. It doesn't mean that if you don't get a decision you like, you should appeal it, because your likelihood of appeal is limited by the facts that you present. So those strategic decisions have to be made with qualified lawyers involved and people who can evaluate the record and evaluate the evidence that was presented and the procedure that was implemented to ensure that a legally valid rendering is given to a party. So I hope that helps. Have a great day.